Hi, everyone. We're just going to give everyone a few minutes to filter in. Thank you for joining us. We'll start in just a second. Okay, we're going to give it just one more minute. Thank you to everyone for your patience and for joining us this evening. All right, I think we might as well get started. Thank you so much to everyone for joining us tonight for our 2022 virtual annual meeting for the ACLU of Rhode Island. We're very excited to have this event with all of you tonight. My name is Hannah. I'm the policy associate at the ACLU of Rhode Island. We're joined tonight by many very smart and wonderful people, but I do just want to briefly introduce the other members of our staff. Our assistant to the director, Megan, who is our PowerPoint director for the evening, and our executive director, Stephen Brown. I just want to thank everyone on behalf of all of us for joining this evening. But before we get started with the main part of our event, I do just want to give a few housekeeping notes. First, we are offering auto-generated captions for this event. Please keep in mind there are sometimes inaccuracies with this service, but we do think it's better just to include it. To enable captions, you can just click on the live transcript button at the bottom of your Zoom video screen. And also, just like usual, like with all of our events, we've reserved time at the end of the program for questions. If you have a question, just click on the Q&A icon at the bottom of the Zoom screen, type your question in the box that pops up, hit return to send the question. The questions will queue up on our end. We'll get to as many as we can throughout the program, or excuse me, at the end of the program, but you can submit them at any time. So please feel free to. We actually encourage you to submit them as we go along. And so briefly, just to go over our event program, we are going to do a very quick recap of what 2022 looked like for the ACLU of Rhode Island. We're going to do a roundup of some of our litigation highlights from this past year. We're going to present our Civil Libertarian of the Year award to Peter Wagner on behalf of the Prison Policy Initiative. We're going to do some questions, and then we'll conclude. I'm crossing my fingers, right on time. So we are just going to start with an overview of, like I said, some of our very notable highlights and victories for the year. For that, I'm delighted to turn the screen over to Heather Burbach, who is the board chair for the ACLU of Rhode Island.
Thanks, Hannah. And on behalf of both the executive board, myself, and the entire affiliate, we are very pleased to have you join us this evening. As always seems to be the case, it's been a crazy year for civil liberties, and we'd like to highlight for you some of our victories in securing the rights of Rhode Islanders in 2022. Since we just had the big election last week, I thought we'd start with some of the successes we've had in securing the all-important right to vote for all citizens. First, we worked hard with coalition partners to get the Let Rhode Island Vote Act passed, which makes voting easier for many Rhode Islanders by expanding early voting and making mail voting more accessible. This bill makes permanent the victory we achieved in 2020, where our lawsuit permitted Rhode Islanders to vote by mail without the need for witness signatures or notaries during the height of the pandemic. Since the changes went into place, hundreds of thousands of votes have been cast this way in Rhode Island. For those who wish to vote in person, the Rhode Island ACLU worked hard with the Board of Elections to stop their pattern of moving polling places in low-income and minority communities without notice or explanation. New rules have been created thanks to our advocacy, which provide voters with adequate notice and make sure that there's a compelling reason for the move. The last victory related to voting that I want to talk about has to do with where people's votes are counted and who represents them. For years, people who at the ACI were counted as voters in the district where the prison sits, rather than where they lived. And this led to outsized representation for Cranston and underrepresentation for those other communities. This year, we finally had some success in correcting this inequity. You're going to hear more about this later tonight in our presentation for Civil Libertarian of the Year. In addition to voting rights, we were able to successfully advocate in many other areas. In one instance, we successfully reminded a school district that if someone has legally changed their name, the district is required to issue the diploma in the legal name, not the old name. This was an important victory for LGBTQ+ students. Next, we worked hard to ensure that invasive and abuse-prone new technologies, like the police license plate reading cameras that are being promoted by Flock Safety, are not utilized without safeguards and prevent privacy intrusions and excessive spying on citizens. These technologies scoop up huge quantities of data on every person and vehicle that is on the road and puts all of our privacy at risk, and our work on this issue is ongoing. At the legislature this year, we had several long-fought battles come to a successful conclusion, and we did this working with coalition partners. First, we were able to get ACLU drafted legislation passed, which permitted undocumented Rhode Islanders to legally obtain driving privileges. This legislation resulted from years of work and advocacy and will help make our roads safer. Next, as you've probably heard by now, legislation was passed legalizing marijuana in Rhode Island. The ACLU worked hard to make sure that the version of the law that was passed looked at the harms done by criminalization of marijuana and took steps to correct them. Sometimes, despite our best efforts, advocacy fails and we have to go to court, but we've had some significant victories in court this past year. An ongoing case right now challenges the treatment of a 13-year-old Black honors student in Pawtucket. This girl was unlawfully handcuffed, arrested, and paraded past her peers so that the school resource officer could, quote, make an example of her. That suit is ongoing and recently survived the school's attempts to have it dismissed. In another case, legal work from the ACLU ensured that the jail treats juvenile offenders the way the law requires, and that they aren't held in custody longer than necessary. The law, which had been passed by the General Assembly, ensured that juvenile offenders serving lengthy sentences are given an opportunity to show that they've changed and deserve early release. After we filed suit, the state agreed to follow the law for these young people, and it has resulted in multiple individuals being released. Finally, and remarkably, despite the horrifying actions from the Supreme Court this past term on an array of issues, the Rhode Island ACLU had many other legal victories. I'll start with the Rhode Island Supreme Court, which declared unconstitutional the state's civil death law. That law declared anyone serving life sentences civilly dead, thus prohibiting them from filing suits, such as challenging inhumane conditions that they were being incarcerated in, protecting their civil rights, or even getting a simple divorce. The fight against this law has been long and a hard battle for the Rhode Island ACLU, and we are very excited about this result. At the US Supreme Court, our long battle with Brown University and their unfair treatment of women's sports teams under Title IX ended victoriously. Efforts to get the Supreme Court to overturn a settlement restoring the women's team that the university had initially cut were to no avail, and the teams are being reinstated. The last case I will highlight is a huge issue for many of us: abortion and reproductive care. Since Rhode Island passed the Reproductive Privacy Act codifying Roe v. Wade, opponents went to court to challenge it and ask that it be thrown out. After the Rhode Island Supreme Court upheld its constitutionality, their last resort was the US Supreme Court. But last month, that court refused to hear the challenge, meaning, at least in Rhode Island, women retain control of their own bodies. I hope that this very incomplete list gives you a sense of the scope of our work in this past year. It's always important to remember, though, that cases that we handle involve real people with real stories, and to review some other significant issues we've taken on this year, including cases involving freedom of speech, data privacy, medical marijuana, pregnancy discrimination, and freedom of religion. We're now going to hear from some of the plaintiffs themselves.
Thank you so much, Heather. I really love what you said about the fact that everything we do at the ACLU of Rhode Island really is about ensuring that the real people behind our cases can fully exercise their civil liberties. And I think that's a great way to transition to talking about some of these cases. So we're very lucky to hear from many of our plaintiffs and volunteer attorneys from the past year. To start, I'm very glad to introduce Alexandra Morelli, who is our lead plaintiff in the lawsuit that we recently filed against RIPTA and United Healthcare for their data breach, which compromised the personal and healthcare information of thousands of individuals.
Thank you. And I do apologize. I'm going to share my statement from the press conference, so I'm going to have to hop off. I'm sure there's plenty of interesting, and there already is plenty of interesting information that's being presented. So if there are any questions specifically related to this case, I'm sure Stephen can answer them. So I am, as Hannah had introduced me, one of the main plaintiffs in the class action lawsuit against RIPTA and United Healthcare. From my understanding, thousands of individuals were affected, but I can personally speak to the stress that this caused me. Earlier this year, I was notified about the data breach, and since then, my personal and financial information was compromised in multiple ways. Within a period of a few weeks, there were fraudulent withdrawals totaling thousands of dollars from my personal savings account, and several of my credit cards had fraudulent activity and purchases. Despite taking advantage of the free credit monitoring that was provided, I had spent countless hours navigating a dysfunctional system without any assistance to undo the damage caused and prevent further damage. This entire experience was and has continued to be extremely frustrating and anxiety-provoking. I submitted reports to the Federal Trade Commission, reached out to the RIPTA hotline several times, contacted the Department of Administration, filed reports with the local and state police, spent countless hours communicating with my bank, and contacted the Attorney General's office without any success. My last recourse was to contact the local news in hopes that someone could assist me. I'm still confused as to why and how my information was shared with RIPTA, since I've never used this service, and extremely disappointed that RIPTA neglected to take responsibility and failed to advocate for myself and others affected, besides contracting with a hotline that provided inadequate support. To date, I'm still monitoring all activities and had to freeze several of my accounts, which I will add is very difficult during the holiday season. I experienced the effects of the data breach around the time I was planning my wedding, and it remains a matter of concern during my pregnancy. Although I appreciate the work ACLU and the cooperating attorneys are doing and have done, I am not participating or did not choose to participate in this lawsuit because I'm happy to do so. I'm participating in hopes to bring awareness to this issue and help others that may have been impacted or will be impacted by this data breach. There must be many other people like me who have had to deal with the problems and anxiety that this caused. It's another reason I feel the lawsuit was so important, because nobody else should have to go through the taxing experience. Thank you.
Thank you so much, Alexandra, and thank you for joining us this evening. We really appreciate it. We're going to turn now to a case which is very topical, considering that Rhode Island just this year legalized recreational marijuana. I'm going to ask attorney Carly Iafrady, who is our volunteer attorney on Callahan v. Darlington Fabrics Corporation, to discuss this case that was filed on behalf of a graduate student who was denied employment because she was a registered medical marijuana user.
Thank you, Hannah, and thank you, Meg, and thank you, Steve and Lynette and everyone in the office that does all the work to handle all these cases and address all these issues. And I can only imagine the thousands of other issues that don't get addressed. So I just want you to know I really appreciate what you're doing over there, and I'm happy to participate. I think it's especially important, and Christine's case is a good example of this, that the ACLU is there in the event that we have these issues where a particular person might not otherwise be able to afford to get their own representation. So I know what that's like. Obviously, I turn away a lot of people, but in this particular case, a lot of times somebody like Christine wouldn't have pursued it but for the help of the ACLU, just because she would not have been able to afford it. and the value of recovery might not have been something that another lawyer would have taken on a separate basis, if you know what I mean. And so I think that's one thing to point out at the outset, that it's really a benefit to sort of every citizen to have you folks there and available to pursue these kinds of things. So this is sort of an old case that we're only talking about it now because it finally resolved at the end of 2021. But the original lawsuit was brought in 2014, believe it or not, challenging the employer's decision not to hire Christine for this particular internship that she was uniquely qualified for on the basis of her graduate studies. And the reason that they did not hire her was specifically because of her status as a medical marijuana card holder. And in particular, she was a very direct, open job applicant. And when they told her that they would have to drug test her, she said, hey, listen, I have a medical marijuana card and I'm not going to pass your drug test. But my understanding is, and she was up on her rights under state law, she said, my understanding is you can't essentially not give me this job because I have a medical marijuana card or a condition that qualifies me for that status. They had done their internal decision-making and decided they didn't necessarily care, and that they would figure, I guess, that this graduate student who really was only coming to them for this internship would probably never do anything about it. And they were wrong. And what was great about it is, we did some discovery and we got a good decision on summary judgment that essentially said that the employer was potentially liable under the statute. There was a private right of action, and that they had in fact violated the plain language of that statute. And we could move on to essentially a trial on the discrimination claims and on damages. At that point, we did engage in settlement discussions that went on for some time, ultimately resolving the case at the end of last year, able to get Christine some of the financial relief she was entitled to, although it was not, any gigantic amount of money, and corresponded to her lost internship. And also, and I think more importantly, we were able to get some attention drawn to the issue. And I think it put it on the radar of a lot of Rhode Island employers that this was something that they had to consider and not necessarily factor into their hiring decisions. And so I think it's a lot less controversial now, especially with the more recent legalization of recreational marijuana. But I want to just sort of end with a point that but for someone like Christine, for pursuing it, we may not have been able to sort of achieve this outcome that does benefit so many other people. And importantly, a lot of people like her might have just said at some point, like, what am I doing this for? I'm not getting the internship back. I've moved on in my life. It's not worth a gigantic amount of money. But she had a strong constitution, or has a strong constitution, and she stuck with it. And I really admire her for that. So even though she's not here tonight, my hat's off to her, because she stuck with it for 6 years when she really didn't have to. A lot of other people would have said, what am I even doing this for? But she didn't, and she really believed in it. And I really appreciate her for doing it.
Thank you so much, Carly, and thank you for your work on this important case. We really appreciate it. So we're now going to turn to one of our First Amendment cases for the evening. We're going to talk about a successful challenge to an ordinance in Pawtucket which limited the posting of political signs on residential property. And I'm very happy to introduce our plaintiffs, the newly elected representatives to the Rhode Island legislature, Cherie Cruz and Jennifer Stewart, to speak about their lawsuit, Stewart v. Pawtucket.
Hi, I'm Jennifer Stewart, and I just want to start by thanking the ACLU for helping me and Cherie challenge this unconstitutional, longstanding restriction in Pawtucket, limiting how long yard signs for political candidates can be up and displayed. It was a 30-day restriction. And I was so happy that Cherie joined the case as a co-plaintiff. This restriction, I think, was only intended to benefit incumbents by limiting the ability of non-incumbents to effectively get the word out that an office is that that I was running for office, and that there was actually a contested election for the Democratic primary. In my case, I was unaware of the restriction, started putting signs up, and then was informed that the Board of Canvassers learned that I had violated that law, and then they threatened to fine my campaign and supporters who had the yard sign up unless we took them down immediately. And so that really got the ball rolling on my end to challenge this restriction. And I would hand it over to Cherie to talk about her connection to the case.
Thank you, Representative Stewart. First, I want to underscore the important work of the ACLU in all these cases, from privacy to patients' rights to criminal legal justice. It's so important. And then in our case, democracy, really, and freedom of speech. So for myself as a first-time political candidate, preparing for a highly contested 4-person primary, it was important that I got my name out there as soon as possible, especially since I was considered an underdog and not endorsed by the mayor or any major parties. I began distributing my signs to supporters, but I found out secondhand and then confirmed with Pawtucket city officials that if anyone put up the signs more than 30 days prior to the election, I would face fines. After hearing this, it was very troubling for me personally, due to the fact that the city of Pawtucket was given notice of this unconstitutional ordinance and given information on the decades of lawsuits deeming this practice just blatantly unconstitutional. That was shared by the ACLU of Rhode Island in 2018 when I was chair of the board. So yet clearly at the time, the city of Pawtucket chose to ignore these facts and maintain this blatantly unconstitutional ordinance to limit residents of Pawtucket's rights to their electoral free speech. I thought we can't, on one hand, call on our citizens to be active participants in our democracy, then on the other, create these arbitrary timelines for that same participation. Thought, this is quite hypocritical and wrong. So, for this lawsuit, I saw it as a big win for the residents of Pawtucket, for free speech and for democracy. And the settlement of the case reminds us that we must constantly fight against practices that negatively impact, the lives of our residents, including the denial of our most basic constitutional right, which is freedom of speech. And hopefully the city of Pawtucket and other cities learn from this and, not to uphold these arbitrary limits and violate or limit in any way our most basic sacred constitutional rights. So thank you so much to the ACLU for all you do.
Thank you so much to both Jennifer and Cherie. Thank you for being here. Thank you for speaking about your case. We're going to move on to another employment discrimination case now, in which a newly hired employee was immediately terminated upon the company learning that she was pregnant. So I'm actually going to ask our plaintiff, Julia Schultz, and our volunteer attorney, Mark Gagliardi, to tell us about Schultz v. Bellamy Goslin.
Hi everyone, I'm Julia Schultz. I'm the only plaintiff on this case. So this actually dates back to 2021, about a year and a half ago. I was pregnant pretty newly pregnant. I was about like 4 or 5 months at the time. And I went out for a job with Mary Maids in East Providence. I was offered the job pretty quickly. I went in for initial interview. She pretty much offered me the job on the spot. I returned a few days later for like my first day, kind of like introducing to the job and everything. And I was immediately like taken into a back room. So I was immediately kind of embarrassed. And then I was asked directly by the owner if I was pregnant, and I confirmed that I was. And she immediately said that she would have to rescind the job offer, that it wasn't an appropriate job for someone who was pregnant. And her exact wording, which really struck me, was that I needed to be home taking care of my precious gift from God, which is obviously very outdated. In the world today, plenty of women work, plenty of moms work, and we juggle it all, and that's what we do. So that struck me. It was kind of my first experience with any type of real discrimination. I'd never experienced anything like that. I went in my car, I cried, and my mom was actually the one who encouraged me to reach out and just try and find help somewhere, because she was like, this is very illegal. You have a very good case here. And I was lucky enough to kind of be handed through a few people and eventually to the ACLU. And Stephen Brown has been phenomenal. My lawyer, Mark Gagliardi, has been amazing. They're always there to answer any questions. They've really kind of like stuck this case out with me. So I really appreciate everything that you guys do. And I never would have had the courage to do this if it wasn't for people, like other people, telling me, you have a case here and this is serious and this is something we need to bring attention to. And I'm honestly proud of myself that I've been able to do that. So just thank you so much to everyone who's been behind this. I know there's a lot more people behind it. And yeah, I'll let Mark kind of say a few words. I'm sure I missed some things.
No, that was terrific. Thanks for having me, everybody. So I'm sure Carly Iafredi will agree with me that we are never surprised at how clueless some employers are. You would think that somebody, even if they don't know much about the law, would know that they can't do what they did to Julia. But I am, baffled that this still happens. And I think, I have a sort of a unique approach to these employment cases. I often say you don't have to prove that the employer is evil to show that they violated the law. The most important language in the statute is because of. If you take an adverse employment action against someone because of, and in this case, it's sex. Rhode Island doesn't call it pregnancy discrimination, it's sex discrimination. If you fire somebody or refuse to hire them because of their sex, it's illegal. It doesn't really matter what your motives are. If your decision is motivated in part on that, it's illegal. And Julia's right, and Lynette Labinger was very big on the negative stereotype aspect to it. And I respect that. But the way I look at it is we all have to follow the law. Like when you leave, and go home tonight, you can't text and drive. So we all have to follow the law. Employers are no different. And when they violate the law, people like me and Carly, we're going to be the first ones there in line holding them accountable. So this case, we have a sex discrimination case. We actually have a disability discrimination claim too, because of the perception that they believed Julia was disabled. The facts, they are what they are. I fully expect them to deny they're going to say that. We're trying to resolve it now, and we'll see what happens. But if they're not going to be reasonable, then it's game on, and we'll take it to a trial if we have to.
Thank you both so much, Julia and Mark, for your remarks about this case, and thank you both for your work. Before we move on to our next case, I just want to remind everyone that if you have any questions throughout any part of this program, please feel free to use the Q&A box as enthusiastically and liberally as you'd like. We encourage you to submit questions at any point. Please feel free to do so. This next case was a big victory for religious freedom in Rhode Island. It was a situation where we actually threatened suit, and the town of Coventry granted a zoning permit to a small Wiccan church whose request had initially been denied. So I'm pleased to hand it over to Gail McHugh and Daryl Moore to tell us more about their situation.
Good evening. First of all, I really want to thank Lynette Labinger and Stephen Brown and Heather Weaver and our local coordinating attorney, Julia Crescent. Without them, we wouldn't have been able to, get the case resolved. We're the co-senior clergy of Horn and Cauldron Church of the Earth, which is a Wiccan church. We formed this church in 2009 in South Kingstown, and then we moved to Coventry in 2013. Now we've been operating above board and not hiding anything for 9 years here, and we're incorporated with the state of Rhode Island, and we have a 501c3. So we've been operating legally the whole time. So the issue of religious discrimination came up. First of all, in 2018, we were granted local property tax exemption, and then in 2020, it was revoked because we had a new tax assessor. So we went about the appeal process, and we had to hire an attorney and all that. And during the course of that appeal, we were told that we were operating a church illegally, and we had no right to operate a church in Coventry, and we didn't have zoning. So we said, okay, so how do we go about the zoning? So they told us how to go about going through the planning and zoning board. We went to the planning board, and they said, there's never been a complaint. It fits in with the comprehensive town plan. There's absolutely no problem here. And they gave us the stamp of approval. They sent it forward to the zoning board. The zoning board was another whole story. They were very hostile towards us and made us jump through lots and lots of hoops and spend a lot of money on attorney's fees, as well as other engineering and architectural design things and all this, when actually we're a nature-based religion, so most of our services happen outdoors. We had to get, all kinds of inspections and this. So we did all that. We returned to the zoning board with all of our ducks in a row with our attorney in May, and they flatly denied us the special use permit. So they said, you cannot operate a church in Coventry. Come to find out, there is no place in Coventry that has a zone that is zoned for churches. So we reached out to the ACLU, and they quickly responded, and they did prepare for a federal lawsuit to get the town to overturn that decision. And that they went through hours and hours and hours of, and I'm talking about the ACLU attorneys and our attorney, hours and hours and hours of negotiations, and put so much effort into it, and finally got the decision overturned. So we did get our special use permit finally. So the town did not even realize that they were violating our First Amendment rights, our 14th Amendment rights, and also they were breaking the law of the Religious Land Use and Institutionalized Persons Act. So we are very, very grateful that we reached out to the ACLU, and now we have a special use permit to go ahead and do what we've been doing for all these years. Thank you.
Thank you.
Thank you both. Oh,
Well,
anything to add? I don't want to.
no, I'm just so grateful for the ACLU for how fast that they did respond to this. When we submitted the application, the feedback I got was it's probably about 6 months before we would hear back. And within a couple of days, there was a phone call saying that you were interested, wanted to take it on. And so I am so grateful because we never, the church basically would have had to close down.
Right, and it's not just about us, but about minority religions all over the United States.
Yeah.
Religious groups.
Thank you both so much, Gail and Daryl, for being with us this evening and for talking about your case. We really appreciate it. We do have one more case to talk about. Surprise, I'm actually the plaintiff for it. The ACLU famously loves open government. A tenet of open government is the ability to access government, and particularly important to this is the Access to Public Records Act in Rhode Island, which is the state law which allows for individuals and organizations like the ACLU to request records from government agencies and entities. Not infrequently, this act will get violated and either records will be inappropriately withheld or requests will be inaccurately responded to, like in my case, where I filed a request with the city of Providence because the ACLU of Rhode Island wanted to know the reasoning behind the Board of Licenses suddenly issuing a cease and desist for an upcoming show at a local club. We thought that there might be some First Amendment implications, so we were curious as to what their reasoning was. And we actually received a response from the city saying that copyright law prohibited them from releasing some of the records and that I couldn't receive other records because those records were required to be kept confidential and under an entirely irrelevant law, statute. We thought that didn't make any sense. We filed a lawsuit only to be told by the city of Providence that there actually were no responsive records, making it even more confusing for them to claim in the first place that these irrelevant laws allowed them to withhold records when apparently there were no documents in the first place. So this case is still currently in process, but we did want to bring it up just because we think it's a really good example of some of the work we do, which isn't super flashy, but still very necessary and very critical for open government and civil liberties, and also just holding the government accountable to its own laws. So that does conclude our litigation summaries for the evening. It is now my honor to turn our agenda to the presentation of our Civil Libertarian of the Year Award. I'm going to hand it over to our Executive Director, Stephen Brown, to present this award.
Thank you, Hannah, and thank you everybody for joining us tonight. And I'm really pleased and honored to be presenting the Civil Libertarian of the Year Award. I first heard the phrase prison gerrymandering about 12 years ago while preparing for a news conference with Peter Wagner on that topic. The 2010 census had just been completed, and Rhode Island and communities like Cranston were preparing for redistricting. I recall the news conference sort of vividly, actually. It was held on the grounds of the ACI, where we encouraged the city and state to address this serious voting problem. But what I also recall is that until that news conference, I had never thought about or even heard about prison gerrymandering. And I was really blown away by it and wondered how I had never realized what an extraordinarily significant voting rights issue it was for our state. What I also didn't know in preparing for that news conference is that Peter and the organization which he founded, the Prison Policy Initiative, had already been fighting this issue for a decade. They had been leading a national effort to urge the Census Bureau to count incarcerated people as residents of their legal home addresses. Now, for those of you who are still unfamiliar with this term, prison gerrymandering refers to the redistricting practice of counting every individual in prison or jail as being a resident of that facility rather than their home community. I won't go into the details, but I can tell you that the impact of this counting decision for purposes of one person, one vote can really be enormous, especially in a small state like ours. The voting strength of the communities where people incarcerated at the ACI come from is greatly diluted, while the political influence of city residents in which the prison is located is greatly inflated. Since that news conference over 10 years ago, Peter and his colleague Alex at PPI have worked tirelessly with our affiliate to address this problem. We've testified at numerous Cranston City Council meetings together. We worked together on a major lawsuit, which unfortunately resulted in a disappointing ruling from the Court of Appeals in Boston. But we then redirected our efforts towards the General Assembly. And all that work came to fruition this year when the legislature, in preparing new district lines based on the 2020 census, reallocated over 40% of the ACI's population to where we think it should be counted for redistricting purposes, back in their home communities. And I think it's inevitable that the next time around, we'll see the entire ACI population properly reallocated. Today, when we realize just how significant the power that redrawing district lines has on electoral influence, The Prison Policy Initiative's educational and advocacy efforts over 2 decades have almost single-handedly brought the problem of prison gerrymandering, not just to my attention, but to the attention of the entire country. It has led to more than a dozen states, including now Rhode Island, and hundreds of municipal and county jurisdictions across the country taking steps to reject prison gerrymandering and make the redistricting process fairer and more equitable. I'm sorry that we can only express our gratitude to the organization on a computer screen, and that everybody watching can't physically join in expressing their thanks to all those at the Prison Policy Initiative who are responsible for this achievement. But putting that unfortunate technological drawback to the side, for their steadfast work in ensuring proper electoral representation for many of the over 2 million people incarcerated in prisons and jails across the country, for working in innumerable other ways to address the harmful impact of mass incarceration, and especially for their assistance to our affiliate on this and a variety of other prison issues over the years. The ACLU of Rhode Island is very pleased and honored to present this year's Civil Libertarian of the Year Award to Peter Wagner and the Prison Policy Initiative. So Peter, thank you. We really appreciate all the work that you and your organization have done.
Thank you. I mean, this could not have happened without groups like the ACLU of Rhode Island and the Rhode Island ACLU specifically. This started off as a solo project when I was in law school, and very quickly though became a big group project. And then we have a team at the Prison Policy Initiative, and now we have a national movement because of partnerships like these. So when I was in law school, I was looking for a way to kind of explain to people how many people were in prison, because there were so many people in prison that it was starting to break parts of our society that are actually borderline unrelated to the criminal justice system. And one of those is elections, because our whole system of one person, one vote was designed before mass incarceration. The Census Bureau counts people as if they're residents of the ACI and not of their homes, basically because they do, and because 200 years ago it didn't matter. And for the purposes of determining how many seats in Congress Rhode Island got, it didn't matter whether you counted somebody in Providence or Cranston, as long as you got them in Rhode Island. But the concept of one person, one vote, the concept of drawing state legislative districts on the basis of population was a relatively new concept. That really didn't become important until a bunch of Supreme Court cases in the 1960s. And then there was not too many people in prison until the 1990s. So this is a relatively new phenomenon, but there's now so many people in prison that it starts to reach out and break other parts of our society, our democracy, and then changes the how political decisions are made in the legislature on a whole host of issues, but particularly on criminal justice issues. And this really kind of matters because there was a pair of about 2 districts in Cranston. There were about 12% incarcerated, each of them. So every group of 88 people who lived near the prison in Cranston were represented as if they were 100 people from Providence or Pawtucket or from anywhere else. And when I started this in law school, I figured early on, like, all right, I think this is unfair. Then I realized, wait a minute, most states have constitutional clauses or statutes that say that incarceration doesn't change a residence, but this was just, so the data that the Census Bureau produces is actually not what the states need, and this conversation was not happening. So how can we get the numbers into the news? How can we get this legal disconnect into the discussion? And I wrote this paper about New York. And because in New York, at the time, half of incarcerated people came from New York City. Almost all of them were incarcerated upstate. There was a state senator who used to brag. He had Attica and 7 other prisons in his district. He would brag, I'm glad incarcerated people can't vote because I know they wouldn't vote for me. And this became one of the thumbs on the scale of why criminal justice reform was so hard to happen in states like New York. And so I worked to put a number on this problem, wrote this report, showed up at a legislative hearing in New York and said, hey, I understand you're almost done with redistricting, but have you thought about starting over because your data is flawed? This did not go well with the legislature, but the civil rights groups liked it and the media liked it, and eventually was then able to start taking this research project to other states and to turn this into a national movement, and which is really because makes this partnership with the ACLU so important, because I and my colleagues, like, we spark this movement, we do the research, we partner with folks, but, you know, and for 12 years, about once or twice a year, Alex and I have been going to Rhode Island when Steve and some of the other partners in Rhode Island ask us to help do meetings, do legislative testimony, but day in, day out, it was the ACLU that was helping people in Rhode Island connect the dots, pushing them to address this issue. Because you know when the most convenient time to talk about redistricting is? Tomorrow, the day after tomorrow, maybe next week, next year. They do not want to talk about it. And you really have to push them, or you blink and the deadline is gone. Because redistricting happens once per decade, and if you don't get organized early, you're done. And so it's really a testament to the ACLU that we're able to get this victory, that almost half incarcerated people are counted properly in Rhode Island. Hopefully we can get that done. We can get all of them counted properly next year. And I want to say that, like, this is a big victory in Rhode Island. We're going to make it even better in Rhode Island, but it's also making change nationally, because the Census Bureau is starting to feel the heat. The Census Bureau very much wants to produce data that is useful to the states. And when states start spending their own money and time to fix something that the Census Bureau could do easier, that gets the Census Bureau's attention like nothing else. So this victory in Rhode Island is putting tremendous political pressure on the Census Bureau to introduce a national fix. And so that's like where this victory that the ACLU led in Rhode Island has like a double duty. It's a big win for democracy in Rhode Island. It's a big blow against the prison industrial complex in Rhode Island. And it really sets the stage for a national reform to solve this problem in all 50 states. And so for that, I really have to thank the ACLU for awarding our work for this and for recognizing it. But I really have to thank, Steve, for coming out to that press conference 12 years ago and saying what the legislature didn't want to hear. Well, if you don't think about this as a policy field, we're going to start looking into litigation. And that right at that press conference, that's the moment in which the legislature started being willing to take meetings. It's really starting to think about this. And so all these victories are because of the ACLU and how the ACLU pushes for justice and for democracy. And so for that, I really have to commend the ACLU for making this victory and for all of your work that you talked about at this meeting here today possible. So congratulations to all of you, and thank you.
Thank you so much, Peter. Thank you so much to the Prison Policy Initiative, truly for all of the work you've done and continue to do. It really is an honor to have you with us tonight. So thank you again. Somehow, very ahead of schedule, we've reached the final portion of our evening. So I just want to remind everyone, please, if you have any questions, please submit them to the box. We're going to do a few questions now. One of the first ones I have actually is for Peter. What are some other prison reform issues that your organization works on that you would want to highlight just very quickly before our program is concluded? Sorry to bring you back on the screen as soon as you muted yourself.
Oh, that's fine. We do a lot of work around the high cost of phone calls home from prisons and jails. And also trying to take on some of these related technologies and profiteering, like why do incarcerated people in some facilities can have access to email? That's good. Why does it cost 50 cents to send an email? Why are many prison facilities, prohibiting people from sending in cards and letters from their loved ones? Instead, they're scanning it and digitizing your kid's mail. Why are we commercializing the dehumanization of people and making it harder for people to succeed on the outside? So those are the kinds of things that we try to draw attention to.
Great. Thank you so much again for your work, and thank you for giving us a little more information about what PPI does. You do a lot of very broad and very important work, so I thought it'd be interesting to hear a bit more about that. We also have a question actually for Gail and Daryl. We're just wondering, did you get any support from the community while this was going on? Just curious about what your experience was like with that.
Well, it was mixed. We got support. Some of our neighbors wrote letters of support, and And we had one neighbor in particular that was not supportive at all. And they were making up excuses like it might be a fire hazard if we have a church, or it might be a parking problem and we might not be able to get emergency vehicles through if we have any vehicles parked in our driveway and things like that. So it was a mixed bag. We had some support and some not support.
And some of the support that we had was discarded by the board, by the zoning board, because they believed that they were too friendly with the board, with the church. And so they didn't count.
Thank you so much. We also have a question for Julia. Kind of similar, actually. Have you gotten any feedback from filing your case? What has that been like from the community for you as well?
So it's actually been the same. It's been very mixed. I've definitely had people that are of the opinion that a pregnant woman should not be working, especially a physically demanding job. I've had some people make comments online on posts about my case that, you know, I'm crazy, I'm a bad mom. So that's been very hurtful. But on the flip side of that, I've actually had a lot of support. I've had women that have actually applied to or worked for this company, this particular company, and they had a similar experience. So I'm not the first person that this has happened to. I'm just the first person to actually do something about it. So that was very empowering. So that's actually been very rewarding.
Thank you so much. And thank you to you, Julia, and you, Gail and Daryl, for coming forward with this issue, because it really does, as you've seen, it makes a huge difference. So thank you to all of you and all of our plaintiffs for taking that step and doing that. We have another question for Peter. Does the PPI, have they thought about challenging the prices, the commissary charges prisoners for basic necessities?
We don't have a litigation strategy for this, and we don't have litigation strategies for a lot of things, but it's something that we've done a lot of research on in some other states, and have tried to kind of make the policy argument about why commissary shouldn't be so expensive. And its corollary is most incarcerated people either don't have jobs or they're getting paid pennies an hour to mop floors, make food, or very rarely work in a factory. So almost all the money that comes in for commissary, which is, and what do people buy in commissary? Sometimes it's gifts for your family. Sometimes it's a treat to keep yourself mentally sane. And a lot of it is food to offset the food that you're not getting provided to you by the state. So why am I changing the subject to where does the money come from? Because most of the money then comes from family members who have to send it in. And in almost all states, you can't send in a check. You have to send in a payment to some kind of special outside vendor where there's an $8 fee to process the deposit. So and often there's a limit on how much you can send in. So mom end up having to give an $8 tax every time she wants to send $25 to her son. So that's something that we're trying to draw more attention to, and to get the Consumer Financial Protection Bureau or the FTC to kind of to do something about that. I don't remember the specifics offhand in Rhode Island, but I can look that up. Commissary, we put a lot of thought into how to talk about commissary, how to do some of the messaging around commissary, because sometimes the prices, I will say, we're going to talk about all states. Sometimes the prices in the prison commissary are more expensive than in the local store or the local bodega or Costco, and sometimes they're cheaper. And I'm just going to say to this audience, that doesn't matter, because the economies of scale are different and the social purposes are different. Costco is trying to make a profit, and they have to do, they have all kinds of different things, versus a very small menu of what's sold in commissary for a certain social purpose. That's why the facility runs it. It doesn't have to be profitable. It doesn't, they have other choices about how these prices could be done. So there's a lot of policy options. It's just very challenging to get policymakers to want to do something about it. On the other hand, we did get them to do something about phones. So I don't have a concrete plan, but if this is on the ACLU's radar, happy to share what we know and brainstorm.
Great, thank you so much, Peter. I just want to let everyone know, we saw some hands raised. We don't have the ability to allow for participants to speak. If you want to ask a question, it has to come through the Q&A box. So that's at the bottom of your screen. It just says Q&A and it looks like 2 speech bubbles. If you type your question there, we'll try to get to it. If we are not able to get to any question, to all the questions tonight, or if you have some leftover questions, please feel free to email us. We love to answer questions. We do it all day. Please email us. We're happy to answer them. I think maybe we'll do just a few more. I think I'm gonna direct this one to Steve, I think, but what are the implications of the Callahan case now that Rhode Island will be beginning recreational marijuana sales in just a few weeks? What is the landscape of employment look like now that we're facing down the beginning of recreational marijuana in Rhode Island?
Well, in terms of medical marijuana, nothing has changed. We have a good court decision that Carly was able to get for us that makes it clear that employers cannot discriminate against the medical marijuana card holders when it comes to employment. The new legalization law also addresses the issue. And while there's a bit broader language than we would like in terms of creating an exception for certain safety sensitive jobs that we think is overly broad, the new law also provides protections to people applying for jobs or working who may be using marijuana. There's an obligation really on the employer to show that the use of marijuana is impairing their ability on the job. They cannot monitor their employees 24 hours a day and say they're going to discriminate against somebody in the workplace because they're using marijuana, which is now legal, and it's not affecting their work at all. So it's a very positive development, essentially expanding what was in the medical marijuana law to people in general who are making use of this new legal drug.
Awesome. Thank you so much. I don't know why I did that. So I think we probably are getting to an opportunity to conclude our program early, but I do just want to encourage anyone again, if we did not get to any questions you have, if you have any lingering thoughts or concerns or feelings that you want to share with us, we welcome you to email us, to get in touch with us. There will be a survey going out after this program where you can please, again, feel free to share your feedback on this event. And I'm just gonna throw it back to Steve one more time to give some closing remarks.
Thanks again for everybody for sticking around to hear everybody. I think we had great speakers and panelists talking about some really important issues. What I wanted to just mention is sort of make a pitch for the ACLU. We just had election results. We now know that Congress once again is going to be very divided. We aren't going to be able to count on them to pass many laws protecting civil liberties or civil rights. We definitely know we can't count on the United States Supreme Court to do that for the foreseeable future. But as I never tire of pointing out, the extent of our civil liberties and our civil rights it doesn't really count what happens at the federal level to a large extent. Instead, it's what's happening in our own front yard, in Rhode Island, in local communities. That's where the rubber hits the road. That's where the real protection of civil liberties occurs. And I hope that tonight's program, going over some of the issues we've had to handle, makes that clear. So what does that mean for you? It means that if you care about these issues, we encourage you to get involved with the ACLU. You can sign up for email alerts. You can attend a legislative advocacy training that we'll be having early in the new year. We encourage you to follow us on Twitter and Facebook, or at least on Twitter for as long as it's still around, to keep informed about what's going on in Rhode Island. And we hope you'll take the time to let your state and local officials know that you're watching them and demanding that they do the right thing when it comes to civil rights and civil liberties. But the one other thing that I hope you'll do is make a special donation to the affiliate. We need your funds to help do all the work that you've heard about tonight. If you appreciate what you've heard, about all these battles and successes we've had in this past year. I hope you'll help us continue to meet them by making a special donation. It's very easy. You can go directly to our website, riaclu.org. There's a nice donate button at the top of every page. And if you can make a donation as generous as possible, we really appreciate it. But ultimately, whatever you do, I thank you for your interest in our organization. I thank you for taking the time to attend. And to close it out, I'll just send it back to Hannah now.
And I'm just gonna say one more thank you to everyone for attending. Probably the most, if you did a word map, those probably would be the most used words of the evening. Thank you so much to all of our plaintiffs who joined us. Thank you for coming to the ACLU with your situations and trusting us with that. Thank you to all of our volunteer attorneys. Thank you again to Peter Wagner and to the Prison Policy Initiative. I honestly am feeling a good emotional at the end of this, because it's always so good to see all of the work that we've done and see all of the wonderful work that people around us in our communities continue to do. So thank you again for joining us, and have a good rest of your evenings.